They frame me in a picture, Sharpie horns on my head, every rumor like a scripture. They repeat what they were fed. Yeah, I'm walking through the whisper, let them burn me in their tails. I keep receipts in my ribcage, every scar, every deed. Call me the villain, paint me in black, blame every crack in your heart on my back. But when the curtains falling and every mask is gone, you'll see the villain was the hero all along. Yeah, I'm the villain, I'm the hero all along.
Toyota.
We're following new developments this morning into the investigation in the shooting death of one-year-old Cohen Wiley at a Walmart in Senatobia, Mississippi. The officer responsible now on administrative leave. Action News 5's Jared Thomas live in Senatobia this morning, where we were expecting to see more demonstrations at the Walmart this morning. Jared, you've been there for quite some time. What can you tell us?
It's quiet right now, but what I can say is that officers and sheriff deputies have been patrolling the area, and also there are a few officers at the front of the Walmart, as you can see, kind of standing in the area just to make sure that no commotion is happening and everything is safe and peaceful. Now, we have heard from the Senatobia police officers and Tate County Sheriff's deputy who responded to this Walmart Sunday after receiving a shoplifting complaint. Investigators say officers encountered two adults and a one-year-old child getting into a vehicle and attempted to stop them. According to the Mississippi Bureau of Investigation, the driver then moved the vehicle toward officers, nearly hitting one of them. An officer started shooting at the vehicle, which left the scene and later arrived at the nearby hospital, where they pronounced one-year-old Cohen Wiley dead. Another person suffered from critical injuries and no officers were hurt.
People need to just stand up. It's in this community today, it's in mine too, but it may be on my doorstep tomorrow.
I want the public to be heard that the Mississippi Bureau of Investigation will conduct its independent investigation. We have 5 agents working on this case, gathering statements, gathering evidence.
Cohen's family says they have received few answers about what happened and are questioning the use of force. His grandfather is calling for justice, while other relatives say they are struggling to understand how a shoplifting investigation ended with the child dying. Cohen's mother told officers there was a baby in the car and they started shooting anyway. Commissioner Tyndale says investigators will release evidence, including video, to the public once the investigation wraps up. Now, civil rights attorney Ben Crump will be representing the family. Meanwhile, officials still have not yet released any information to the name of the person who was shooting at the vehicle or any charges or potential charges that could be coming after this case. For now, I'm Jared Thomas reporting live in Senatobia. Action News 5.
Shooter supposedly left the scene.
New details tonight in a story we first broke during a live report at 5 o'clock. 27-year-old Stephen Tyler Whitehead is charged with murder. He's being held in the Jefferson County Jail without bond. And this stems from a shooting early this morning off of Highway 75 in Jefferson County in the Palmerdale area. Multiple people were shot at a gathering where there were around 20 people hanging out at what people refer to as the pit. ABC 3340's Valerie Bell has been working for you to provide the very latest information. She shares what she's learned so far.
The Jefferson County Sheriff's Office is investigating after 4 people were shot. We obtained the dispatch audio that captures the frantic moments first responders raced to find the victim.
Caller stating it's a female patient who's been shot in the head.
The call came shortly after midnight. A chaotic scene unfolding deep in the woods off Highway 75, behind no trespassing signs and a narrow trail locals know all too well.
Got 2 shots, 2 male shot here at the scene, and somebody's trying to transport a female that's shot in the head.
The location difficult to pinpoint.
Copper, I don't know if they're in the woods or what.
Yeah, they're going to be somewhere in the woods, the call taker said.
People living nearby say the spot, known as the Pit, is a late night hangout for teens and young adults.
It's been going on for a long time and there's not been any problems. You know, your typical teenagers that try to find somewhere to go to listen to the music and do whatever they do.
But early Sunday morning, that peaceful night erupted in gunfire. The sheriff's office says 2 men ages 21 and 18, as well as an 18-year-old woman, were all rushed from the scene by medical crews from Palmerdale, Centerpoint, and Trussville. A fourth victim, a 20-year-old woman, rushed to the hospital in a personal vehicle.
It's scary to hear something that close to your home.
Neighbors like Denise Roberts say this kind of violence is unheard of here.
You don't want anything to happen to anyone, so, you know, I don't understand, you know. I don't understand why it has come to that between people, kids, or whoever.
27-year-old Steven Tyler Whitehead of Brookwood is now facing charges. Investigators say the shooting stemmed from a verbal and physical fight that escalated into gunfire.
No more handling things out behind the barn. You know, people pull out their guns, and that's not right.
The Jefferson County Sheriff's Office is urging anyone with any information about this incident to contact them or Crime Stoppers. You can remain anonymous. In Jefferson County, Valerie Bell, ABC 3340 News.
And Jefferson County Commissioner Joe Knight represents this district where the shooting happened. He tells ABC 3340, "I hope the injured recover. I hate that it happened, and it shouldn't have happened, but it did. When you start shooting in a crowd, you have collateral damage, and it's sad." We're also taking a closer look into the suspect, Stephen Whitehead's background. And according to court documents, Whitehead had an assault charge out of Bibb County from 2020.
Oh, well, good evening, people. Good evening. How are we doing? I wanted to play those two cases right there. It's two different cases. One is a very sad case coming out of Senatobia, Mississippi. A 1-year-old was shot, as reported. So the mother and other ladies, I think it was another lady or whoever else was with her, they were suspected of shoplifting. Sorry, they were suspected of shoplifting, and the police tried to detain them, and allegedly they took off on the police and almost hit a police officer. And so when they shot into the car, they shot one person. What's going on, Mike? I might have to play these over for you. What's going on, Mike? How you doing?
Same old.
I know this is going to be an easy one for you, but hopefully I can make it a little bit challenging for you. But introduce yourself. Tell everybody who you are. Wherever on X. I know you got a lot of followers. I know a lot of people know who you are, but still introduce yourself.
Instructor Mike out of Chicago. Just a guy who knows a few things. That's all.
A few things. Okay.
Just
You're
a
being
few,
modest right now.
just a few things, you know.
Okay. You know what? I'm gonna play something for you, and I'm gonna see what you think, and I'm gonna ask you a question afterwards.
All right.
So let me bring this up.
The shooter supposedly left the scene.
New details tonight in a story we first broke during a live report at 5 o'clock. 27-year-old Steven Tyler Whitehead is charged with murder. He's being held in the Jefferson County Jail without bond. And this stems from a shooting early this morning off of Highway 75 in Jefferson County in the Palmerdale area. Multiple people were shot at a gathering where there were around 20 people hanging out at what people refer to as the Pit. ABC 3040's Valerie Bell has been working for you to provide the very latest information. She shares what she's learned so far.
The Jefferson County Sheriff's Office is investigating after 4 people were shot. We obtained the dispatch audio that captures the frantic moments first responders raced to find the victim.
Caller stating it's a female patient who's been shot in the head.
The call came shortly after midnight. A chaotic scene unfolding deep in the woods off Highway 75 behind no trespassing signs and a narrow trail locals know all too well.
Got two males shot here at the scene, and somebody's trying to transport a female that's shot in the head.
The location difficult to pinpoint.
Copper, I don't know if they're in the woods or what.
Yeah, they're going to be somewhere in the woods, the call taker said.
People living nearby say the spot, known as the Pit, is a late night hangout for teens and young adults.
It's been going on for a long time, and there's not been any problems. You know, your typical.
That's just a brief one. All right, so that what happened was, and I'm gonna try to tie it in to what we're talking about. So down in Alabama, it was a bonfire. One guy was there. He was 27. Of course, there was some teenagers there, 18, 19, probably even a little bit younger, but there was drinking involved. And they didn't like the kid, whatever the case may have been. They started jumping on him. So it's two people on one that I know of. If there was more involved, so he pulls out his gun and starts shooting. And I'm gonna play this for you, and then afterwards I'm gonna try to tie it back in.
Toyota.
We're following new developments this morning into the investigation in the shooting death of 1-year-old Cohen Wiley at a Walmart in Senatobia, Mississippi. The officer responsible now on administrative leave. Action News 5's Jared Thomas live in Senatobia this morning, where we were expecting to see more demonstrations at the Walmart this morning. Jared, you've been there for quite some time. What can you tell us?
It is quiet right now, but what I can say is that officers and sheriff deputies have been patrolling the area, and also there are a few officers at the front of the Walmart, as you can see, kind of standing in the area just to make sure that no commotion is happening and everything is safe and peaceful. Now, we have heard from the Senatobia police officers and Tate County Sheriff's deputy who responded to this Walmart Sunday after receiving a shoplifting complaint. Investigators say officers encountered two adults and a 1-year-old child getting into a vehicle and attempted to stop them. According to the Mississippi Bureau of Investigation, the driver then moved the vehicle toward officers, nearly hitting one of them. An officer started shooting at the vehicle, which left the scene and later arrived at the nearby hospital, where they pronounced 1-year-old Cohen Wiley dead. Another person suffered from critical injuries and no officers were hurt.
People need to just stand up. It's in this community today, it's in mine too, but it may be on my doorstep tomorrow.
I want the public to be assured that the Mississippi Bureau of Investigation will conduct its independent investigation. We have 5 agents working on this case, gathering statements, gathering evidence.
Cohen's family says they have received few answers about what happened and are questioning the use of force. His grandfather is calling for justice, while other relatives say they are struggling to understand how a shoplifting investigation ended with the child dying.
All right, Mike. All right. So one of the things that, I was talking with another guy, another brother, and I think he described it because we talked about Graham v. Connor. I'm pretty sure you know, but for all the other people to know, that was a Supreme Court case that talked about what was that objectivity of the police officer and the fast moving situation, and then the deference that's into it. Would you like to enlighten, or you want to say something to it?
Yeah, Graham versus Connor, for those people who are watching, is codified as 490 U.S. 386. 1989. It was a case out of it was under a section 1983 action under Title 42 United States Code section 1983. Those are the type of lawsuits that are filed when people are stating that actions conducted by police officers under the color of the law violated a person's civil rights to be free from such intrusions, and there was an excessive force claim. And so the standards by which, evaluations of civilian use of force is different under a subjective standard of malicious intent versus an objective reasonableness standard. That standard being, what was the officer doing at the time of the arrest, and what was the objective they were trying to achieve? What were the facts and circumstances known to the officer at the time of the arrest? And would a reasonable, prudent officer, if they were put in the position of that officer, would they have likely done the same thing to achieve the objective that they were trying to achieve at that time? As it states on the screen, Graham was a diabetic man who ran into a gas station to get orange juice to treat his blood sugar. Found the line too long. Officer Counter became suspicious, conducted a traffic stop. Graham resisted arrest and became injured. Case went to the Supreme Court, and they said, well, the type of force that was used wasn't even reasonable because of what was going on at that given time. And so with this case in Walmart, it's going to be, first of all, subjective reasonableness or objective reasonableness doesn't even come into light until there's the investigation done by the Mississippi Bureau of Investigation to see, to see if what the officer did was objective under whatever their use of force policy is. And I can almost assure you that if you look at the objective, right, it's a shoplifting thing. Pampers don't cost that much. When you look at Pampers not costing that much, you look at the total value of what was stolen. It doesn't even arise to the level of a felony. It's a misdemeanor.
But one of the questions would be, how were the officers to know that at the time? Right.
Well, yeah, I mean, how would the officers know that at the time? But if they're going there for a shoplifting complaint, let's just say it was in fact a felony. If you're looking at it from a Graham standard, let's look at it from a Tennessee versus Gardner standard, because Tennessee versus Gardner is the other case that, those are the two most central cases. Now, I'm not saying it was theft, Frida, and of course I shared it to my platform as well. So you're going to get people from Instructor Mike page coming on here.
Yeah, I see.
Let you know. And that's good. Yeah. And I'm not saying it was a theft, but I'm looking at it from a law enforcement lens, that the officer comes in response to a call for a shoplifting. Even if it was a felony that took place, it is a non-violent felony. You see what I'm saying? And so even though the action could be non-violent, let's just say they stole something worth $1 million. Let's raise the bar on that. Her leaving the store and getting inside of a vehicle does not ipso facto, or by that very fact, rise to the level of force that you need to use where a firearm would be involved, because now you're talking about a moving vehicle. That's one of the things that I've criticized, from a force analyst perspective. That's one of the things that I criticized about law enforcement, is that even if you do discharge your pistol and you do in fact stop the person driving, it does not stop the vehicle.
Let me get this introduction in right quick. And Joe Lanu, how you doing?
Doing well. How you fellas?
I'm all right. Instructor Mike, this is Joe Lanu. Joe Lanu, this is Instructor Mike. I played a series of videos, 2 videos, and I think me and you talked before about the deference that the deference will go to the police officers in a fast moving situation. But if you don't mind, Mike, I'd like to play a little bit for him so he can see what we're talking about.
No, sure.
All right, and just a lot of stuff that was going. These are 2 cases. I know that one case is coming up in Alabama that is going to be that's coming up for trial. He's facing murder, and then I think 3 attempts or maybe 2 attempts, but he's facing that. And then this other one is the one in Senatobia, Mississippi. I'm gonna bring that up and I'm gonna start that over.
Mother told officers there was a baby in the car, and
Did it freeze up or it just freeze up for me?
now civil rights attorney Ben Crump will be representing the family. Meanwhile, officials still have not yet released any information to the name of the person
that low
shooting at the vehicle.
Yeah, it's pretty low.
Any charges or potential charges that could be coming after this.
All right, what I'm gonna try and do, let me see what this. Oh, that's I know what it is with the volume.
Action News 5.
Should play again. Here we go. All right, here we go.
It's a Toyota.
We're following new developments this morning into the investigation in the shooting death of 1-year-old Cohen Wiley at a Walmart in Senatobia, Mississippi. The officer responsible now on administrative leave. Action News 5's Jared Thomas live in Senatobia this morning, where we were expecting to see more demonstrations at the Walmart this morning. Jared, you've been there for quite some time. What can you tell us?
It is quiet right now, but what I can say is that officers and sheriff deputies have been patrolling the area, and also there are a few officers at the front of the Walmart, as you can see, kind of standing in the area just to make sure that no commotion is happening and everything is safe and peaceful. Now, we have heard from the Senatobia police officers and Tate County Sheriff's deputy who responded to this Walmart Sunday after receiving a shoplifting complaint. Investigators say officers encountered 2 adults and a 1-year-old child getting into a vehicle and attempted to stop them. According to the Mississippi Bureau of Investigation, the driver then moved the vehicle toward officers, nearly hitting one of them. An officer started shooting at the vehicle, which left the scene and later arrived at the nearby hospital, where they pronounced 1-year-old Cohen Wiley dead. Another person suffered from critical injuries and no officers were hurt.
People need to just stand up.
Think you got enough, Joe, from that case?
Yeah, I've got enough.
All right. And the other case, and I think, we were talking about civilians and civilians and police officers, but I'm gonna bring this to the stage and try and start it over.
Try to find somewhere to go to
Jefferson County Jail without bond, and this stems from a shooting early this morning off of Highway 75 in Jefferson County in the Palmerdale area. Multiple people were shot at a gathering where there were around 20 people hanging out at what people refer to as the pit. ABC 3340's Valerie Bell has been working for you to provide the very latest information. She shares what she's learned so far.
The Jefferson County Sheriff's Office is investigating after 4 people were shot. We obtained the dispatch audio that captures the frantic moments first responders raced to find the victim.
Caller stating it's a female patient who's been shot in the head.
The call came shortly after midnight. A chaotic scene unfolding deep in the woods off Highway 75, behind no trespassing signs and a narrow trail locals know all too well.
Got 2 males shot here at the scene, and somebody's trying to transport a female that's shot in the head.
The location difficult to pinpoint.
Copper, I don't know if they're in the woods or what.
Yeah, they're going to be somewhere in the woods, the call taker said.
People living nearby say the spot, known as the pit, is a late-night hangout for teens and young adults.
It's been going on for a long time, and there's not been any problems. Your typical teenagers that try to find somewhere to go to listen to the music and do whatever they do.
But early Sunday morning, that peaceful night erupted in gunfire. The sheriff's office says 2 men ages 21 and 18, as well as an 18-year-old woman, were all rushed from the scene by medical crews from Palmerdale, Centerpoint, and Trussville. A 4th victim, a 20-year-old woman, rushed to the hospital in a personal vehicle.
It's scary to hear something that close to your home.
Neighbors
Need
like
more, Joe?
Bruce Roberts say this kind of violence is unheard of here.
No, I guess not. If there's no particulars, I understand how everybody feels about it, but I don't know any particulars. Somebody got shot at a bonfire.
I don't understand.
All right. So that's the particulars of it and whatnot. And like I was talking about earlier with the deference and whatnot, so what the details is in Alabama, the guy was getting jumped by 2 other guys. He pulls out his, I don't know if it's a Glock. I'm not going to just say all that, but I know he pulls out his gun and he shoots 2 people, and he shoots 3 people, kills 1, and then wounds the other 2. Now the other 2 were charged, I think, with assault. They were charged with assault for jumping on him, but this case is still lingering and going on. And then the first case we were talking about was Mississippi, which is being investigated by the MBI, Mississippi.
Hang on, let's go back to Alabama. So there was a female shot in the head. Everybody was very clear about that. Was she one of the persons that were attacked? He claims to be attacking him.
No, it was the 2
or was
guys.
She a bystander?
I don't know. I don't know if she was a bystander, but I think she was trying to break it up. There are some reports out there that she got in the mix of it and trying to break it up.
Okay.
All right. Any other questions?
No, you want to talk about the one at Walmart?
Oh, the one in Walmart. Well, yes, the police officer. As you've seen in the reports, it said that the lady was trying to drive away a flee, and drove in the direction of an officer. When that's when they shot and fired. Now the body cam footage is not out yet. Like I said, the NBI is still doing an investigation. She did do an interview. The woman, I don't know if she was shot, but the mother of the child, she did do an interview where she said she did pay for the Pampers. There was a receipt. But for whatever reason, I didn't hear in the video why she pulled off or whatnot, but she did. And that happened in the results of that. Mike, you got any other insight of it that you want to talk about?
Yeah, I saw the young lady, not saw, but I saw the interview of the young lady who had it was more so of an impromptu interview in the car, and she was very calm, talking about what occurred. She said she held her baby up in the air, either inside the car or outside the car, to let the officer know that there was a baby in the car. Whether we find that odd or not, I would leave that to a person to have their opinion about it. But that's what she did, and then she attempted to drive away, and the officer pulled out his firearm and shot the car. So, of course, we would like to see the body camera. But I'm listening. Go ahead. You got more. Because there's definitely more to add with this.
Yeah, and from what I've seen, I think some of the reports I've seen, when they showed the car, there were gunshots. I mean, there were bullet holes from the front. Now, that doesn't mean that it couldn't have been, shooting from the back and exiting out the front, anything like that. But it looked like those were entrance. But I can't tell just right off of looking at a what's that? But the reason why I brought this up, because if the officer, now this is not me saying, trying to Monday morning quarterback it, and they say that we didn't find anything that was wrong with it. They were trying to make an investigative stop. They were trying to stop them. They drove off, or they almost hit an officer, or they were going in the direction of an officer. Would he be given deference at that time, where the police officer was justified in his actions, even though the 1-year-old was killed? That's a question for both of y'all, either or.
Being a police officer who has responded to calls for shoplifting, having worked in off duty at Walmart, I don't see the exigency in this. I don't. It's a shoplifting. People shoplift all the time. And so there was a case that had just gone, I think it was on, I think the Supreme Court had accepted the writ of certiorari. I forgot the name of the case. It's a more recent case where either they opined about officer-induced jeopardy or not, but the Supreme Court didn't really address it. But it is a thing where a percentage of officers would then put themselves in positions with good intentions, by the way, with good intentions to, stop the car, or do some other type of thing. And it creates a situation that causes them to think that they are about.
I think it was a Texas case, wasn't it?
It could have been, I don't know. But it causes them to think that they are about to then lose their life, which then creates that subjective fear that I should then draw my firearm and shoot. But any firearms instructor, any use of force instructor who is independent and, objectively reasonable would say, well, even if you shot the person and they lost their life, that still doesn't stop the moving car. You still would have to make some kind of movements out of the way so as not to get hit, if in fact that's your objective. And so multiple things can be true. That point can then still be true, and I'll land on this. That point can still be then true, but I could also see, systems are not just paper, it's people. And so, how I say that self-defense is a community standard. Well, these cases, even though it's involving the police, can in fact be community standards of its own. Like in Chicago, would that fly now as opposed to back then? Probably not. But someplace else, it might fly. Cases have to make it up to the court for the court to then rule on the matter. Just because Graham exists doesn't mean it may automatically be upheld by whatever these judging entities are, state's attorneys, whatever the case may be. They'll do what they do. So this is going to be an interesting one to see. I'll land on that.
All right, Joe, you got anything? Joe, did you freeze up?
No, he's moving. I see him. Yeah.
Oh, okay. Oh, he's looking something up.
Yeah.
No, he's looking at his phone, but go ahead.
Yeah, we're talking Graham versus O'Connor, and there was a case that modified that. Barnes versus Felix, 2025. I don't even remember when it was going on. I just read this recently, but it modified Graham. And Graham laid down a few things when it comes to use of force, in particular with law enforcement officers. You guys are talking about it, deference for a quickly evolving situation, and they should be viewed without the benefit of hindsight, right? These are the things that we pull out of Graham versus Connor. But there was another thing in there, and exactly what Mike was talking about, is that the officer cannot create the exigent circumstance, right? The officer can't put themselves in harm's way, and the vehicle is used a lot of times this way. Y'all have heard me talk about this on the grand jury. It's a fine line when an officer stands in front of the vehicle. Let's go back to the Renee Good case. It's alleged there that the officer put himself in there. It's the same assertion in this. There's technically some issues with that the evidence disproves completely, but let's just say that where he was at, he had one person on the ground. He has one person in the car. He's got another officer coming up to make contact to the driver of that vehicle through the window, typically in a traffic stop style. He's standing off to the front passenger's right side, putting himself in a position both to cover what's going to go on inside the vehicle and whatever this idiot on the side here that he's been talking to. So he's got himself in what I call a tactical advantage position. I say an officer has a right to do that. That's not creating the exigent circumstance. I don't know about the Walmart case. There's really not enough to really know. And the other thing you guys are talking about, there's the Supreme Court's never gauged an officer's intentions or good intentions. It's good faith. And there's a difference. The good faith means that whether they had a receipt or not at the time, the officers in good faith believed that they had probable cause, right? Now, they may have made contact. Oh my God, the diapers have a receipt. This technically was not a crime, but in good faith, the officers executed their duty. And anybody that watches my show, The Grand Jury, you'll see this with me almost every time an officer shoots inside of the car. Jason and I, my expert witnesses, have butted heads on this a little bit because I think it's a very fine line. I can't stand in front of your car to stop you from going, right? Because if you challenge me, I only have one thing left. I have to kill you. I have to shoot at you because I don't have a car, right? And so you can't stand in front of a car to say, stop, you go no further. Because now we're in the line of, did you shoot him for getting away or did you create the situation? And I think that's what you're talking about, Instructor Mike. In the Walmart situation, and I can see where you can make an argument that the officers in good faith I didn't know he was driving away until he drove away, right? There's the whole thing to it. Let me go back to Graham versus O'Connor. Graham versus O'Connor actually established something that was very pro-police. And the most pro-police portion of that is that they said that rather than view the situation, the totality of circumstances, everything involved, from the time that the Walmart, in this case, the 911 call, these mofos stealing my Pampers, from that point forward, Graham versus Connor says you can't use that. You can only use the immediate instant prior to deadly force being used. Well, this is an advantage in an officer. If I initially stood in front of your vehicle to stop you from leaving, it almost does. The only thing that the court could examine was, were you scared of the car? Well, yes, I was after I stood in front of it to prevent this guy from leaving, right? So I stood there to prevent him from leaving, couldn't be considered. Barnes versus Felix changed that. And so I think it's a great ruling. I stumbled upon it, and I watched the Supreme Court, especially with this type of stuff. And this one slipped through in like April, May of 2025, a year ago. And I just recently read it. But what it does, and I agree with this, and I think you guys probably would too. It says that, no, you've got to look at everything, the whole totality of the circumstances. Now, to a good actor, this is positive, right? Because it allows me to set what I was thinking. We can bring the 911 call in, the dispatch, the communication as you're going to the call, right? We all know, as anybody that's ever shagged a call in their life, that there may be a big difference in reality and the 911 call you've got, but you're already thinking about it, right? I've got a domestic man with a gun. I'm already thinking what I'm going to do, right? I'm not going to stop in front of the car. You know, you're going over things. So that's my mindset when I get there. And I get there, it's not a man with a gun. I've still got to process that. But let me back up. I just think that what they say now is that
don't forget we got to get Mike in there too. So
the entire look, man, if I'm talking too much, my bad. Yeah, now go ahead.
I'll do the same thing. So I'm.
I know this is my second show, and I've done more sitting and doing this than I've done talking. Right? So, but now go ahead.
No,
Mike.
That's the case that we was talking about. I just didn't have the codification and the name of it.
Brother, I had to look it up. That's what I was doing.
Yeah.
I couldn't remember the name. I knew it had some. I was thinking it had some weird Spanish name to it. But it's Barnes Felix. That's the case.
Out of 2025. But the thing is, it extended, Graham, because one of the things is that we talk about totality of the circumstances under Graham, but circumstances has various meanings to a lot of different people, and that's where Barnes v. Felix came in talking about, and when determining what is reasonable, don't ignore the events that created the scene. Now, this was important because the Fifth Circuit that the case came from was looking at the moment of threat, that these things took place, but then at the moment of threat, that's what should be highlighted. And the Supreme Court unanimously rejected that, even though it's the whole thing, not just the moment of threat. Another thing that the court does, and if you listen to the courts, and I love going to oye.org, which is the Supreme Court, so you can listen to the disputation.
Oh yeah, that's a great website.
Yeah. And now YouTube has started to host various channels that have the disputation too. But prior to that, Oye is the website of the court where you can go and listen to Graham versus Connor. I invite anybody to go back and listen to the litigation and the litigants argue before the court, the then Supreme Court, on Graham and Tennessee versus Gardner. It is just wonderful if you're into that type of thing. But what the Supreme Court loves to do, they did not adopt an officer-created jeopardy rule. And that can be both good and bad, and I can see it being more bad than good, because not every police department invests in officer training. And so you get certain places where the training is litigation mitigation. Is just enough to be able to say we met the state minimum standard, whatever that is, just to put bodies to respond to the call. And so now you get officers, and especially nowadays, depending upon where you are, and especially in Chicago and the suburbs and stuff, we see more new boots with no life experience, no real too much of anything coming in. And so they have to make these decisions, and the court, will protect the institutions against these types of things, because look, we need somebody to respond to these calls, and so if we create an officer-induced jeopardy rule, that would do more harm to the corporations, if you will, because every city and every county, every state.
Do you think that CBD? Do you think that Chicago has made a let's say a police officer meal, where they just pushing them through? It's kind of a quirky question, but
because they're losing a lot of officers to a lot of
what else are you going to do?
Absolutely, they got to replace it, so they can maintain strength, because things are not getting better, things are getting they're getting worse. And
the mayor said crime is down, so
I want
to make a comment on the officer-induced mandate. And I agree. I'll be on. I think we have maybe one of the best Supreme Courts we've had. Could be since Mabry versus the United States.
Marbury
Madison. My bad.
A long time ago.
But look at what we've got. I think they're laying down on the fairness. They took Graham versus Connor, which honestly had a bias for law enforcement officers. It really did. If you followed Graham versus Connor, it gave you a lot of deference. Absolutely, it says it in the decision that you have this type of deference, and the deference is that the moment of action, the incident that the violence occurred, is what you should consider. You can't consider how you got there, right? So this is an advantage law enforcement. But I think otherwise, Graham has got some pretty good stuff. I think you should give not just law enforcement officers, anyone deference for a quickly evolving situation, right? In most cases.
That's why I brought up the civilian, the guy in the what's the name
I think they get the. I think they get the same. I think they get the same. I think the difference with the law enforcement officer is that reasonable person is probably a little higher on the scale of what you would expect because they've had some training, at least some training. I think that a police officer has the other aspect of a duty not to retreat. I think those two things are the only difference in self-defense. The citizen, I think, should have, and in my state has, just as much authority and right to defend their life once the reasonable person standard of fear has been met. But my point, going back to a mandated officer cutout, it takes the decision away from the individual jury and the individual jurisdiction. I think in this Supreme Court, I agree with, in many cases, not just in many decisions, not just this, they said there's a point you can't go, but everything else you have to figure out yourself. That's your job. And they're not wrong. That is every individual municipality and jurisdiction. They need to figure out what they think their officers are reasonable or not. And I think that's where it should be decided. I'm glad that they didn't go as far as what you were talking about, but I think the Barnes-Felix case really ties up Graham versus Connor to be something I think is fair for both citizens and law enforcement officers.
And, you know, even with this, and that kind of brings up the question that that I had towards the thing, because you have these fast evolving situations, and like you always said, I'm pretty sure Mike can agree to this, officers don't have the chance to actually rewind it, stop it, slow it down, all of that, right? And training can only go so far. You got so much mandated training, and officers should train outside of their job, or was just mandated by the state just to stay a police officer. I can't tell. I've never been a police officer, so I can't tell the everyday situation. Mike, you want to touch on that?
Context. It just depends on what the circumstances that the police officer is dealing with. There's been some situations that I've been able to slow it down. It just depends. I don't think, in my opinion, from having been a police trainer and, still as a force science analyst, you could talk to Force Science Institute and they will say, even in their conferences, that not every police department trains to a stress inoculated standard to the point where officers can operate with whatever prefrontal cortex exists at that time under the influence of stress. When you have police departments that don't have a physical fitness standard, when you're not in shape like you need to be, then you get to this to the amygdala part of your brain, where it's all about fight, flight, freezing emotions. If you don't train like you need to and you only touch the gun until it's time to use that firearm, that could accelerate that. There's a lot of different factors that go into what could likely increase the likelihood of a police officer accelerating it or slowing it down, of a citizen accelerating it or slowing it down. What type of crisis prevention training are they getting? It's a lot that goes to that. And even some thoughts, and I'll land on this, even some thoughts within the culture of law enforcement with the mindset that, look, I'm a police officer, I'm not a social worker, I'm not this, I'm not that. Yeah, okay, but you do work with the public, and when you end up finding yourself in these cases where the bosses have no choice but to terminate you because it's either you or me, they're going to always choose them. They're going to always choose them. They're not going to choose to back you, depending upon what department you are and the politics involved. So there's a lot of nuance, a lot of abstraction that comes into that conversation. So, can I land?
Joe, I'm going to give you not a response, because it's not really a debate or anything like that, or rebuttal, but I was going to let you say something. But I do want to bring up the... Go ahead.
How about my opinion? Can I just give you my opinion?
Yeah, please give me your opinion. I was trying to find the words.
I think law enforcement vary not only from state to jurisdiction dramatically. They all, if you work for a city, county, or state, you're all enforcing state laws, right? If you work in a city, you got some city ordinances, right? A couple other things you can jack somebody up, write them a ticket for. Typically, in most states, that's what you can do. If you work in the county, but everybody's enforcing state laws. And I think every state now has some sort of minimum standard requirement, both for basic police officer training, police academy, and then continuing education. In Texas, it's every 2 years. You had so many classes that were mandatory, and then you had so many hours of training of stuff that you could pick. You had to do that to maintain your license. If you got down to the last day of the second year, I've never happened to me, but I've known a couple of officers that were struggling to get a course in that was mandated in August, because September 1, their license is no longer valid. But it's that serious. It's not like get it done and we'll come back to you. You cannot be a police officer. You're no longer valid at that point. To go into where we've come from where we started, and I'll say where we started, well, even go back just to the 50s, and we'll call that modern policing forward. Where we've come to where we are now is remarkable. We are getting closer and closer to being a better deal. But there's always going to be problems, but we're getting closer and closer. Part of that is we talk about CIT, and you need to understand we're part of the community. That sounds great. Every officer I know understands that verbal judo is a hell of a lot better than knuckle judo. And that's what you better figure it out. And you can get help with the classes. In Texas, every officer has to have CIT training. It's always part of the class that's in every 2 years. So at least every 2 years, you're taking some sort of critical intervention training for people that are emotionally charged, for people that are having some sort of a mental episode, people that you might not have to shoot if you can just try to deal with, give them a little bit of birth and give them a little bit of room to try to work themselves down. That works sometimes. When it comes to physical standards, all police officers aren't the same. I was listening to a space earlier that we're talking about a police chief in Las Vegas transferred himself to Hawaii. That sounds great in the movies. Also in the movies, when the FBI walks in, the police bow down. Oh, well, Mr. FBI, what can I do for you? Walk into my scene and tell me you're the FBI. You're taking my scene over and see what happens to you. Because by God, I'm the original jurisdiction in the state of Texas, especially as a deputy sheriff. I own the ground I stand on if it's a crime scene. Now, I'll take some FBI help, and we never turn it down. We don't treat them that way. But when they show up, hey, is there anything we can do? Because they do have some good gear when it comes to forensic evidence, and they got deep pockets, and they'll give it away. They're there to do that. My point is that people don't understand how law enforcement works. If you don't like the way law enforcement's working in your town, then you need to figure out who your police chief is. And then you need to go find you a new mayor, new city council, because the police chief works for your city council. So I'm getting off on this. I just want to go back to law enforcement. I want to go back to the law enforcement standards. My point is that depending on the jurisdiction you're in, some cities don't pay enough that you can tell a guy, hey, I need you to maintain some sort of real physical fitness standard, right? In smaller jurisdictions. But in larger jurisdictions, more physical jurisdictions, and Texas, what I observe is that there's a pretty decent both professional standard and physical standard. But I think everybody says training. Don't forget, officers get trained every day. Every traffic stop, they learn something. Every call for service, they learn something. Every meat complainant, they learn something. Hell, in meat complaints, you start figuring out, wait, hey, that's civil. Clear it with a 3. Even if that, but all that's training. You learn what works when you talk to somebody. You learn how not to stand to somebody when you handcuff them because they could grab your damn nutsack, right? These are the things that you learn. So when we talk about officer training, remember, they get training 12 hours a day. If you're out there shagging calls, your training level is going up, and that's really probably the best training that you'll get is good FTO, good senior officers around you that point out things that you're holding your flashlight and your gun hand on a traffic stop.
Hey, I know, Mike, this may be some of your people from in your chat and whatnot, but some of y'all are just downright disrespectful. I don't know. Hopefully y'all can understand that y'all on my channel, and if we're having a good discussion, please don't try and come and derail it. Please don't. Let us have the conversation. Please listen. Hopefully this is something that can benefit y'all. I'm not saying I'm savvy. I know all of the law, but these guys do. They know a lot about the law. They know a lot about the Constitution. They know a lot about being police officers because they were police officers. Mike teaches all the time. I teach. Joe Lunu educates a lot. So why can't y'all just let the conversation happen and stop trying to be rude and asking these dumb ass questions? Oh, you know what? Who's that? Let me see if I can.
Yeah.
Well, what kind of dumbass? I don't see him. What kind of dumbass questions do we have?
You can only block them on your end. I can't because it's not my screen.
Okay. Yeah. I need to learn how to do that because Lord have mercy.
Why are you blocking them? Somebody's got something stupid to say. Let them say it louder.
Raz. All right, so he's asking, are you
Why are we?
homosexual?
Why are we repeating it?
You're right. You're right.
Yeah,
You're right.
yeah.
Because you know what? I'm new to this. I don't even. You know what? I'm new to this. But let's move on with the.
Yeah, don't react to that comment. Yeah, because you're good.
Man, comment don't hurt my feelings. I'm good. I'm fine.
No, I just try to, y'all are my guests. I just try to make sure that y'all get a fair shake and y'all get a fair conversation.
Brother, if you've been a police officer, the first thing you can figure out is your feelings really don't matter. I've been called, I don't give a shit. You right, maybe. You're right.
You're right. All right. So better yet, well, of course, Mike is an instructor. I'm an instructor. And then Joe, I'm gonna ask you this, Joe. How do you think it will be better? How can we educate the populace? We got all these cases that come in, like Renee Good. So many people started arguing that the car, and then they was like, well, she wasn't trying to hit him. And then we say some stuff like, well, you're not supposed to stop, stand in front of a car to stop them. What is the difference between that case and what we're talking about now?
Keep going.
Go ahead, Mike. Go ahead.
I look at it like this. The Renee Good case, I saw the video. The officer was not trying to stand in front of the car. The officer was actually moving around. And when he was moving around, the way that she turned the car into him. And it's like, honestly, she wasn't trying to hit him. And he wasn't trying to shoot her intentionally. It was a collision of two stimuluses, if you will. The wife on the outside of the car telling her to go, baby, go. And then she did that. Him trying to avoid getting hit and had his finger on the gun. And then as she passed by, it was an instinctive, it was a sensory motor response. So I can see that happening as a sensory motor response, not as he intended to shoot.
That makes sense. And then, even going back to Minneapolis and whatnot.
Yeah.
Going back to Minneapolis when we talk about the Alex Peretti situation. I know sometimes we beat a dead horse on a certain subject, but that's a fast moving situation to where, one officer may know that he has the gun on him. The other one doesn't know that he has a gun on him. And I think you said something that was fair, that if he wasn't out there, he wouldn't have got shot. But if you want to respond to that, and then we go to Joe.
So this person who's saying something, Jonathan Raz, they're not on mine because I'm watching it. If they were on mine, I would have blocked them. So he's on yours. So I don't know if you know how to do that through StreamYard. It's 3 buttons on the side. You can tap that and then remove them from the stream, or go to YouTube and do it that way. But yeah.
I'm trying to do that right now, but go ahead, keep talking. Go ahead, Joe, if you want to say something to it.
Yeah. I think the Renee Good is a good example that we try to make the use of deadly force or self-defense, we try to make it complicated. And this is a problem for us citizens. The more complicated, the more duties we apply, or the more expectations we have of the person that we can perceive to be the more responsible one to take care of the actions of someone who's less responsible. But in the Renee Good situation, that's real simple. And it does appear that he's walking around the car, but he's actually stationary. If you watch it from the rear, the front of her, can you guys hear me?
Yeah, I can hear you, but hold on right quick.
All right.
It's saying that the comment is on a guest destination. Only your guest can delete the comment or ban the user.
Yeah.
Now this is on Joe. If you can see it.
I got it.
Okay.
Yep.
Okay. I don't give a shit. Here, I wasn't streaming that now.
I just removed them now. You're good. Keep going.
Good. Go ahead, Joe. I'm sorry.
Hang on. I'm doing tech stuff now. I'll do it in a minute.
Yeah.
Now, on the Renee Good, when she backs up, honestly, it's kind of a weird camera angle that it looks like he just appears because he's not moving. What you do is your eye is focusing on like the passenger side, the T-bar that goes down between the driver's side and the windshield. you kind of, and I don't know what my eyes did it as well, but you kind of focused on that, and you don't really draw your attention away from that until the officer appears over the hood. It looks like he's moving. It's like, bam, he's there. But I took that, I did it on the grand jury. I looked at the frames per second. There's no way he was moving at all. He appears there because of this, I think it was 60 or 64 frames per second. And she's moving so quickly, he only pops up and you don't see him move, you just see him pop up. But the real key to that is pay attention to the orientation of the front of her vehicle. When she changes, she goes from pointing directly at a white house to pointing at a gray house. Who's standing in front of the gray house? The officer. The officer never actually moves around there until he tries to get out of the way, because at that point, that's the closest way to get away. That's the shortest path he had to get clear of the vehicle, was go to the driver's side. But I think one of the problems we have when we look at this now is that we've forgotten hindsight. You know, we know when we watch a video, something bad's going to happen. When the officer's doing it, they don't know. They don't know what's going to happen next. There's no foreboding music. Don't know what her intentions were to get away. That never mattered, right? That never mattered. That's like how many people talk about the Carmelo Anthony case in premeditation, as if premeditation mattered. It may matter to you, but in the law, it doesn't matter. The law doesn't call for that. Self-defense, in my mind, is very simple. If a reasonable person with a set of circumstances and facts that are known to me at the time would believe that their life is in danger, a third person, another person's life is in danger, or serious bodily injury, I have the right to pick up a brick, an axe, drive you over with a car, beat you to death with anything that I can get my hands on, because at this point, I have the right to defend myself by any means necessary. And if I've got a firearms are just fine to do that. To me, that's self-defense. And it extends to police officers, but police officers, I think, should have some bridle on them. And I think Graham, in a few other cases that have been established, you mentioned another one, Tennessee versus Garner. I think there absolutely needs to be bridles on law enforcement use of force. But in general, and in good faith, if they're illegal to be where they're at and their lives are in danger, I think fear is the benchmark that should be waged. And anything else after that, fire them if you don't like the way they did it, but you can't put them in prison.
Yep. You got anything, Mike? And someone did bring up a question earlier where they were talking about the weed case, or either that people that smoke weed or use weed, that they can carry firearms now, and that's a whole.
Yeah, I didn't get too much into that one. I got to read what the court's holding is on that one. I don't know if they I think they put the announcement out. I got to see if it's on OEA so I could get the holding on that. But it's still, even when the Supreme Court decides a case, still has to be funneled down to the states to see how they're going to adjust policy, if you will, so that we can know how to carry out whatever that holding is. Because just because they make a decision, things can happen for free. No, you still got existing state statute that has to be adjusted to that rule.
And it's kind of like
there's not many Supreme Court cases that are a snap of the fingers. The best one is a good example that was same-sex marriage. There was many states that had laws that said that only a man and woman could get married. The day after that, those laws go back to Madison versus Mabry, right? It was repugnant to the Constitution and therefore nullified those laws. But those are landmark cases. Those are rare. Most cases will come down and say that we're okay with you going this far, but maybe not here. And Mike is right. They'll go back down. They'll revamp legislation or just attorney generals just to declare how they'll interpret.
Right. Yep.
Yeah. And I think that's.
But hang on. Go back to the. Talking about the weed case, I'm not familiar with it. Was there a case that's hit the Supreme Court about a challenge to the use of lawful? I'm in Colorado. It's lawful for me to use marijuana, or I have a medical marijuana card, but yet it's unlawful for me to. I could be arrested if I'm in possession of a firearm on the federal
I think
level.
that's what the case is. I'm gonna have to look it up. Maybe that could be a topic probably for next.
Who asked the question? Can they give us any more background? They clearly know more about it than we do.
They did. Hopefully, they can bring it back up.
Are you in control of comments or somebody else? Because I don't feel like
I'm not looking at the comments. I'm looking at the comments. I'm not reacting.
Mike, I like you, Mike. I'm talking shit to Corey. I'm asking who's running this ship here. What's happening?
I'm looking at them, but a lot of
comments got you tore up, got your feelings hurt there. Now you're trying to block people. I can't remove them, and we had to stop talking and figure out how to get somebody out.
I'm just trying to take care of my guests. That's all it is, there, Joe. That's all. I'm just trying to take care of my guests. I'm not gonna let anyone just talk.
My feelings aren't hurt. I don't. Mike's a cop. His feelings. He don't got no feelings either. Heart black.
Yeah, I'm not thinking about that. Yeah. I've been called everything under the sun. I'm
right. Yeah. And if you haven't, you worked. I don't know where you worked. You were a bailiff, maybe.
No, I was.
No, I'm saying if you've never been cussed out, you're a bailiff because the judge will put somebody in jail for cussing at you.
I'm telling you, look, corrections officer and police. So now I've gotten both sides of it. So
I started out in the jail. You guys talk about training, man. I think it's one of the best things you do before you get on the streets is put you some time in the jail, man. You learn a few things there. You learn how to see things that other people won't see.
Mike pointed that out. Mike pointed out, he pointed out the difference between Cook County Sheriff and how they handle someone and how CPD handles someone and how they were in control of the situation. It's magic.
Well, the SO there, right? They run their deputies through the jail first, right, Mike?
That's correct. Yep. Cook County Sheriff's Police, you got to come out of the jail.
Yeah. I'm telling you, it is night and day. You take guys. Look, you take guys. Somebody wants to be a cop, right? They got a clean record, right? They're not running around with a criminal element. They're not around people like that. And now you want them to go out there and be a police officer. But you put people in the jail, right? Even people who aren't like the real criminal element, they just got they got some, I don't know, you got a DWI, right? But you're in jail for more than 30 days. You're gonna, you know what? Jail sucks. If you can get a little something extra, you can get over on the guard, you're going to do that. So there's a constant game being played, but that teaches you, man. I could walk in after doing it maybe 6 months or so. I could walk into my pod and look through the windows and know if something's up.
Yep.
I mean, there's nothing that tells you that. It's like, nah, pop the doors because you know something's up. It's just you could see it in people's eyes, and I don't think you can train it. You just got to be there long enough to see it.
Yep, that's true. That's true. I agree with you on that.
Mm-hmm.
Well, working in jail sucks, though, boy. I used to think I work around people who are locked up all day. When I go to work, they lock me there, lock me in. I can't get out until they push the button and let me out. I'm being locked up too.
Yeah, you doing your time 8 to 12 hours a day.
Yeah, bro, we did 12-hour shifts, boy.
My God, yeah.
Yeah.
Here's the wait a minute, where did that comment go? He said something about it.
Now the U.S. Supreme Court ruled.
So U.S. Supreme Court unanimously ruled in favor of a Texas man, Ali Daniel Himani, determined that the federal law banning firearm possession by habitual drug users violates the Second Amendment.
And the fact that it was a unanimous ruling, that's great. So what this is going to end up doing is this is going to end up amending, I believe, Title 18 United States Code, Section 922. I believe one of the sections, and you typically see this on the ATF Form 4473, where they ask you, are you a habitual user of marijuana because marijuana is still a Schedule I narcotic. And so this is pivotal. This is great because then, this is going to amend a lot because in every state, you got a standard by which you're not able to possess a firearm under the influence of marijuana, and you're not able to operate a vehicle, especially in Illinois under 11501 of the Illinois Vehicle Code, and they are allowed to use the same testing standard for the possession of firearms under the influence as they would the testing under 11501. So this is going to amend a lot of different things in various states' criminal codes. This is going to be interesting. And I don't even know if there's any studies out there to suggest that a person under the influence of marijuana can somehow be reckless with a firearm. I know alcohol, yes. I know other types of drugs, yes. But I don't have any operational experience in my time in the streets that somebody under the influence of weed is going to all of a sudden be reckless with a firearm. I don't see that happening. If anything, under the influence of weed, you're chill. Like,
well, yeah, and then I think that's why the guy down in Alabama, why he was charged, because it's a bonfire, right? What happens at bonfires? There's going to be some drinking. But go ahead, Joe. You wanted to say something.
Yeah, I was looking at that law. That marijuana law is new to me, or the decision is new to me. It may even have further reachings. They go back into the days where they could ban drunkards from possessing firearms, saying that blanket basically what it may be not just with it specifically addresses marijuana users. By the way, this Texas law it doesn't say all drugs. It says habitual marijuana users. That if that's the only foundation, that's not enough to deny them their constitution or arrest them for a violation of this gun law. But it also goes into, let me go back because I was just getting the broader implications, can't speak. The court found that categorical bans on large groups of people without proof of specific dangerousness or intoxication while armed do not hold up under the court's Second Amendment jurisprudence. And I think that right there is I like it. I like this. Once again, I think we have the best Supreme Court in my memory for sure. I think our Supreme Court nails it, and I agree with this decision.
Yeah, I mean, I'm sure they use the Bruin analysis in saying that there is no historical context where the founders of the Constitution, the founders of this country, saw that marijuana, and I could be saying this wrong, I don't know, but there's no history that shows that the founders intended it to be this way. And that's just where I'm going to leave it. I got to read more up on this case.
Now, it's interesting that the history that they used, the state used, was that there used to be laws that if you were a known drunkard in town, you couldn't have a gun. There's evidently some laws like that. And they went back and said, well, that's a blanket law too. So your history doesn't hold up.
Yeah. Well, also, I do want to say that I think they did cite in this case. I've seen something today, Ezell versus City of Chicago. I don't know. It might have been in there. I don't know. Yeah. I was just throwing that in there. Just some people we know. I just wanted to say that.
I think when it comes to gun ownership and the legalization of marijuana, in some states it is, some states it's not. Some you have to have a medical card. They consider it medicine. I think it's difficulty. I think the feds have a difficulty trying to really lay down on that. I think this goes away in this case. I think this case actually probably does it on the federal level as well, because I think it applies there probably faster than it applies in Texas. But I think they've had a problems with some years with what to do with marijuana when in fact it's pseudo legal damn near in every state.
Yeah, but then also they can't. I guess there's no. I guess viable way to test it. That's how I think that's harder for a DUI conviction, right? Like someone's high on weed. But
the burden's on the state. That doesn't sound like my problem as a citizen.
You're right. You're right.
You know,
I don't know.
If you can't prove I'm drunk, then maybe give me a ride home.
Oh, here's the background of that case. It's the United States versus Himani. Codification is, it's out, but it just decided today. 2022 federal agents searched his home. He cooperated, surrendered a firearm, pointed out marijuana on the property, and admitted he used marijuana about every other day. Long and short of it, remember how I was talking about Title 18 USC 922, it's G3. It did not strike it down entirely. So Justice Gorsuch wrote for the court stating that before it was a blanket prohibition, I think you had just mentioned that it was a blanket prohibition. Now, it doesn't strike it, but it says you can't use that by itself. It's got to be another reason. And the beauty of it is that it's particular to that individual person. So they don't exclude drug use. They say it's got to be drug use and this and that. Another reason. And then the drug use just compounds whatever pre-existing problems may exist.
You got to bring something else with it that shows that the intoxication makes them dangerous.
Right. Absolutely.
Yeah. Let me introduce. Hey, Jason, how you doing? You got a 20-year-old retired vet here. He retired from the police department last year. How many years did you do there, Jason?
I'm not 20 years old.
Oh, okay.
I did 30 years, and actually tomorrow is my retirement anniversary.
Oh, okay.
Thank you.
Good.
Yeah, he retired on Juneteenth.
Yeah,
he did.
And my Marine son is putting his fist to my face right now that I'm going to kick in the balls.
I was more worried about the
Good
dog. The
going.
dog was. Does the dog need to go? Get some, some loving or something like that? The dog was
Oh,
back
look,
there.
I swear to God, I'm out of here, dude. You guys bring this up. I'm done. I'm done. No. There's been way
Jason.
too much talk about that.
That wasn't us. That was not us, Joe. That came up from somebody else.
Well,
No,
Jason,
it did, but I may have talked about it too, but I'm putting myself on the same halt list.
Right.
I like Mike, and I don't want Mike to think of me that way.
That's right.
Or anybody else. I don't want you to think of me that way.
Hey, Jason, go ahead and introduce yourself and tell us about your company that you're working with and everything. And just go ahead.
Just retired Juneteenth of last year. No offense to anybody. It was not premeditated. It was just, that was my 30 years. I did patrol, school resource officer, active shooter instructor, narcotics, sergeant, lieutenant, investigations, mental health stuff. I mean, kind of the whole gauntlet in law enforcement. And about 10 years ago, I kind of got sick and tired of nobody's helping protect our kids in schools. So we created a company. It's the only tactical response that's out there. It's not artificial intelligence. It's not all this fucking other bullshit. It's actually providing tools to the kids and the teachers to actually take their school back. And it will save lives. And working on that, but that's where I'm at. We're installed in quite a few schools up here in Minnesota, and we got legislators looking at it. So hopefully it becomes a building code, and we can stop looking at dead children in our schools. But that's kind of me in a nutshell.
Yeah. And after the show, if you want to ask anything about it, Mike, you can. I think it's a great system, and I think it's something that we can work on. Yeah, I seen the system when I was in Minnesota. I go ice fishing, and a lot of people look at me crazy when they say it's a black man that goes ice fishing.
You see a black guy in the ice. He actually wanted to do a snow angel naked.
Yeah, that's right. Yeah,
and I stopped him.
No, so yeah. So talk about that time that you tackled a naked man. How did you want to be a police officer?
Why are you bringing that up?
He doesn't want to tell the story, Mike. But what inspired him to be a police officer was there was a naked guy running around in Minnesota in the cold, in the snow, and Jason tackled him. And he was doing a ride along. Actually, he was doing a ride along that day.
That's true.
I like that comment right there. Ain't no black man ice fishing. Yes, I was up there ice fishing.
Yeah, he was.
Yeah, and I had a whole
Corey
lot of
outfished us actually. Corey was into it big time.
I was focused. I was laser focused.
You were focused.
All right. So, all right, to get back to the subject, we were talking about Graham v. Connor, and how my biggest thing was the deference. And I think a lot of times when we look at some of these civilian situations where you have a fast moving situation, someone fighting, it's a melee. Hopefully, you're not there for the melee. Excuse me. You're not there for the melee. Because I know for me, if they start fighting in the restaurant, I'm out. Yeah, no, y'all got to deal with yourself. Avoid conflict at all times. But if I have to use my firearm in that instance, I mean, what does the line stop? What do you think, Jason?
It's the reasonable standard. I mean, it truly is. It's if you feel like your life's in jeopardy, the life of others, and you can articulate that. But I agree with that, the other side too. And again, my background is law enforcement, so I never had that duty to retreat. And that's my stupid dog. I never had the duty to retreat mindset. And that's the difference is if you're going to kill me or somebody innocent, I just can't help myself. I am going to fight back.
Jason, guys, is our co-host and expert witness on the grand jury every Friday night. We literally address this in five cases every Friday night with five new jurors that make a determination. And we just ask them simply if it's reasonable or not. And we believe that is the standard. That's the standard to take someone's life, is a reasonable belief that my life's in danger. Even though you find out after the fact that there was some, toy gun, the BB gun, all these other factors that people will throw in there, you find that out later. It doesn't hold me more responsible because a thorough investigation revealed that I never was in real threat. If a reasonable person in my shoes would have believed the same thing. And you take the BB gun, all these things obviously are true. So, oh, you threw me off with your message there, man.
No,
I'm not great at this. But my point is that, because I really did have one. My point is that Jason and I kind of align on the reasonable person standard. And I think as of late, we're trying to make this much more complicated than it is. There's a case out of Colorado where a young man used deadly force when four assailants were breaking in the convenience store underneath his apartment. One of them pointed a gun at him. He had an AR-15. He returns fire. But they convoluted that story so much that they lost the thing. Was it reasonable that the young man had a fear for his life? That question, the jury was glazed over because they started making technical. The family in that, it was even told that their son skipped a step. I'm like, shit. How many steps are there in self-defense? Can anybody? I mean, there are people with a lot of words in their mouth that can tell you that there are steps, but the law doesn't show that there are any steps. I mean, the only thing is it reasonable to believe? And I think we lose that when we start the Renee Good, all these other cases we talk about, even the Carmelo Anthony case. They made it much more difficult than what it is, because that standard, when you get down to the law in Texas, in particular, the Carmelo Anthony case, is that the only self-defense is that you had a reasonable fear in that subjective term of a reasonable person.
Well, this question is interesting. Well, not even a question, but statement. I think we need to define subjective and objective. What one person thinks is reasonable, a jury of 12 may not. Anybody want to touch on that?
Well, the law's answered that, and we explain this every Thursday, every Friday night. It's quite simple. The reasonable person is not what you would do. It's not what Mike would do, not what Jason would do. It's not what my dog would do. It's not what any one person would do. We don't find 12 people and put them into a grand jury or on a jury and say, hey, we thought you were all so reasonable that you just tell us how you would have done this and that'll be the right thing. Hell no, that's not the way it's done. The reasonable person is a hypothetical. It's a construct. That person doesn't exist, but they are described as not, we're talking about police officers, not day one rookie and not 30-year veteran. Some officers somewhere in between, the very minimum of what you would expect in reasonableness out of a police officer, that's the reasonable police officer. When it comes down to the citizen, the bare minimum of what you think of as a prudent person, no malice at all, that's the reasonable person. And it's very difficult to do. Self-defense cases are the most difficult cases that we have in our court system, that we ask our jurisprudence system to deal with, because we don't want emotions to come in, but emotions do come in as mental states. And there's no way to know what's going on in someone's mind. So the way the law does it is that what would a reasonable person, knowing everything that this person knew without malice, what would they think? And if that answer is it's reasonable to be afraid, then what happens after that, that person had the right to do.
And even if we look at it from a civil standard too, and attorneys will tell you this, that sometimes people don't take into consideration that self-defense, this reasonableness standard, is a community standard. That what would take place, even though you have, we know how laws are passed, either it starts in the House or the Senate, and then it goes through committee, comes out of committee, comes to a full floor vote, gets passed, tossed over to the other side, same process, tossed in the middle, sent up to the governor, signed into law, and then all of a sudden it becomes a law, right? The majority of the state's representatives then in fact create this law. But how it's going to be decided is on a county by county basis in the manner or in the area where this situation in fact took place. Let's go to the matter of, People versus O.J. Simpson in the criminal case. Well, that was a Los Angeles County case, where his civil case was in an Orange County case. Two different juries, and granted two different standards, but that's a perfect example of how you can have one case that's decided on two different standards, proof beyond a reasonable doubt, a more likely than not preponderance of the evidence, but two different types of juries, two different counties.
Mike, you summed up the problem right there in a nutshell. And here's my problem with the judicial system in our country. It's gotten too goddamn complicated. There's too many laws. There's too much confusion. We've lost the Constitution, and you have civil laws that have gotten out of control. You have criminal laws that have gotten so specific with amendments and everything else. I really do think our country needs to backtrack. we have too many laws, and it confuses people. It's just black and white. Here's right, here's wrong.
Well, you know what? I get what you're saying, and I get the intention behind that, but I kind of want to push back on that, and here's why. Let's focus on Illinois. Illinois body politic is Democrat, but the entire state is a Republican state, and it started out that way until politics started to shift. So would the citizens in the rest of Illinois, like Johnson County, Iroquois County, Sangamon County, where it's more so stand your ground by case law, would they want to be tried with 12 members picked from that county on a Cook County standard? It's like one of those things where we have to appreciate, or we can appreciate the nuance that, yeah, state law says it's this, but try finding 12 members of a jury from this county who don't see it that way, who say, well, here in this county, you kick in this door, we're going to allow this type of force to be used, and it's going to be hard to find a jury in this county.
You're saying we're saying the same thing. What I'm saying is that if county to county, the question is stand your ground constitutional or not? That's the question. And has that been challenged? Are the states passing unconstitutional laws? And on top of that, if you look at the last 5-6 years, a lot of the juries that have been created have been a jury of public opinion and not juries of laws.
Well, yeah, juries, because that's the only framework by which they know. And who decide? And you're talking to somebody, here we go, who's been falsely arrested 3 times, found not guilty 3 times. One case I tried as my own pro se counsel. Not too many instructors, thankfully, have been both a practitioner and a participant in that system to know that in my cases, I'm not going with a jury because what is this thing called the truth is subject to subjectivity, that they really don't know the law. They only understand their experience. And would my attorney be able to craft a story that would help them relate to that thing? And in my cases, I wasn't going to lend that to 12 laypersons who don't understand the law, especially. I'll give it to the judge. And it worked out in my favor all 3 times, but
I'm with you on that sentiment. As a cop today, I'm not sure I want a jury trial.
No, hell no. No.
Well, no, I think
you better not. You better not.
No, God no.
But I think it matters the type of case too. If you have if you have a technical case and by law I'm good, you may not like it, but I'm good. I would take that to a judge, because the judge is going to say, well, you don't have to like it, but that's what the law says. Whereas a jury, if you're looking for compassion, you might be able to find that in a jury. But remember, the jury and what you say, I agree with Mike, that the state on the state level passes laws, but they will be interpreted, and what reasonableness is will be determined by the jurisdiction for which cases are tried. But I think that's what the Constitution founding fathers wanted.
Yeah.
Remember, this was a complaint they had with the Great Britain after the 7 Years' War, when they came in and said, hey, we're not getting enough people convicted on crimes against the crown over here with your little local government. So now we're going to arrest people and we're going to put them on a ship. We're going to take them out in the sea and we're going to give them a court martial. Well, the crown's prosecution rate went up, but the people didn't like that, because they liked the idea of saying, yeah, that may be the law there, but that's not reasonable here for these reasons. Go back to the Carmelo Anthony case. They tried it in this case. I don't think they did a very good job. But one of the things they were looking for as far as what is reasonable in certain situations that you wanted the jury to see is that they wanted color. The fact that his assailant was a large white man and he was a black man, and they did it in the media. They wanted to say, well, historically, that's enough right there to be afraid. But in that jurisdiction, the jury just didn't find that reasonable. Right. But I think that's the way the system is supposed to work, and I'm a big fan of juries. By the way, a jury of your peers means people who are subject to the same jurisdiction that you are. So every juror that's sitting in the jury box, if they're charged with a crime, they'll sit in the same seat that you're sitting in and be subject to the same courtroom and the same process. That's what makes a peer. peer doesn't mean same people look like you, they work like me, that we all get along. It means that they are subject to the same jurisdiction that you are. That's a jury of your peers in the United States.
Nuh-uh, Joe. Nuh-uh. Go ahead. Go ahead, Mike.
But you know what I find interesting is that when you have people who don't really understand the law, and then they move into a county and they don't understand the manner by which in that county or in that state by which juries are picked. If you move in, let's just say if I was to move to Texas, which doesn't sound like a bad idea, it's like a great idea. Whatever county I want to move into, I'm going to get that census data pulled. I'm going to sit there and see what the racial makeup is. Not that matters to me outside of where I'm going with this, but I want to see what the racial makeup is. And I may want to look at some appellate or Supreme Court cases that came out of that area and maybe sit in the courthouse to see how the community fares with regard to certain standards. And because that's where the jury is going to get picked. See, if you move into a community and you're not in that community to learn that community, you don't know what the pulse of that community is like. And so if you commit a crime in that community, don't be shocked when you get what you get, because no way do you have, and I'm going to land on this, you got 45% white, you got other Asians, then you got Hispanics that were underneath, and then black folks in that county, in Collin County, 10%. And of the 10%, how many are registered to vote? How many have driver's license? How many are available for jury service? How many were available and they were
But hold up, the jury pool is not selected by the color of your skin. In Texas, the jury pool is selected by how many, they take registered voters and they take a random draw. The judge and prosecutor and all it could be several defendant attorneys, they may be pulling a jury for several cases. They'll say, all right, we need a pool of 1,000 people just to start with.
Right.
That gives us 1,000 pool. So they do a random drawing of not Social Security numbers, but of registered voter numbers, and they send out the mail notices.
Right.
And then those jurors will come in and everybody gets a button. In fact, the juries aren't really selected. Juries are eliminated. They eliminate the pool there's no reason to eliminate these 12 people. So there's your jury. You don't get selected. You just don't get eliminated. But well, go ahead. Sorry.
No, I'll tell you this too. No, I only talk about the racial component because this is a math numbers. This is the numbers game. It's like if you got 10% of that 10%, what's the likelihood that you're likely going to get, these numbers from that 10%? You can get the number of registered voters. This is open source information. You can find that information out. And so, well, this is the numbers game. What's the likelihood of getting somebody who looks like me? But then there's a catch to that. Given that this is Texas and some other states, just because I look like you doesn't mean I'm going to agree with you.
I think actions too, and the community matters. Like in New Orleans, they had such a problem with carjacking in New Orleans that especially after dark, you didn't stop at a red light. I did work there after Ida. I had guys working. We were doing a 24-hour shift, and I had a guy come back to work one day, and he said, "Man, I got pulled over for stopping at a red light." And I knew what he's talking about because I've been down there long enough. You may see 2 or 3 accidents a week of people that'll come to the red light, slow down, and keep going. They've had carjackings that are so bad there that it's almost unreasonable at 2 o'clock in the morning. There's nothing else coming for you to be sitting at a red light. And in fact, in this case, the worker is doing just that. 2 in the morning, sitting at a red light. There's no other traffic. An officer drives by him, turns around and pulls him over. And he said, "Don't ever stop at a red light at this time of hour." He said, "Somebody's going to take your car." So let's say that this guy it's reasonable. He didn't want to stop because he didn't want to get carjacked, and he T-bones into another a vehicle. I think that you would have trouble in any prosecution on that, saying that his actions weren't unreasonable for the community. So the community goes back to what Mike's saying. The jury of your peers, the community determines what reasonable is. And I think in New Orleans, it's reasonable for you not to stop at a red light because for fear of being carjacked, because it's such a common thing in that community. So once again, though, I think the reasonable, when somebody asked it earlier, who's the reasonable person? How do you know that guy is? You really don't know. And it's one of the hardest things that both prosecutors and defense attorneys are trying to nail down what is reasonable. But juries will determine it.
Well, and we got this question from Mr. Mayhem. How do you define stand your ground? Is there a law to reference that describes it to the letter? Anyone want to take that one?
I can try it. Personally, I think it started with the castle doctrine, which was to protect your home, and then it just kind of evolved over time. The problem with that is it goes into the reasonable person standard as a conceal and carry per person outside of the castle doctrine. So that's where it's a state law. It's not a federal law. And I think the federal law needs to set the tone on this because it varies from state to state to state. So
it needs to vary from. I actually I don't have a problem with it. I think it needs to vary state from state for this exact reason we were talking about before. Community determines what's reasonable, but the stand your ground really is kind of a response to states that started adding a duty to retreat. Stand your ground doesn't mean you have to. It just means that you do not have a legal obligation to try to get away, right? There were many states that even they didn't have a duty to retreat in the way that the statutes were worded. It's like, you almost had to prove you didn't have a choice. And the stand your ground really just removes that from it. It doesn't add anything to your right to self-defense. It removes a duty that has to be proven. And I'll give you an example. In a state that has a duty to retreat, and you have a homicide, and that you're going for self-defense, the state, two things have to be proven at this point. One, that your actions did cause the death of another, and that you did that in fear of your own life. But before all that happened, did you first try to get away? Now, in many cases, they'll say, well, it wasn't feasible, right? But that point is a question that has to be answered. Under stand your ground law, there's only two questions that have to be answered. Did you take the life of another? And was it reasonable to believe that your life was in danger? But without the stand your ground law, that third one has to be answered is, was there a feasible way you could have avoided it? So stand your ground is a doctrine, and many states will articulate how that's done in different ways.
And that's part of that's the argument is after Trayvon Martin, I think a lot of people thought that this was going to create a vigilante exclusion. And that's where I see the conflict there.
Yeah, but it doesn't. It doesn't change. It doesn't change anything. It just eliminated one thing that had to be determined somehow or another in a court.
I'm just saying that was the argument. We're going to create this vigilante thing.
Oh, well,
which I disagree with.
So here's another thing with. Oh, go ahead, Corey.
No, I was saying I was trying to get you in there. Go ahead.
So here's another thing with stand your ground laws. So we know the founding of the country, separating from Great Britain, English rule, stuff like that. It was a common law rule that traced back to the 1600s prior to the founding of the United States, that in English common law, that there was a duty to retreat. Well, when we separated from that and we got into, the United States, now you start to get, the development of the Supreme Court in Marbury versus Madison and judicial review. Then you start getting into others, cases out of Indiana, Runyon versus State, 1877. That court started to see that they were strongly against the rule of people retreating. Then you got another famous Supreme Court case, Beard versus United States, 1895, Brown v. U.S., 1921, and on and on and on. And then it was made, I don't want to say kind of popular, but popular because of the Trayvon Martin case out of Seminole County, where Florida has had in 2005 a stand your ground law. And this was before Trayvon. But even in Illinois, we have our own stand your ground law by case law. And case law is what's decided at Illinois appellate and state courts, as well as
which one
federal.
was that? Rodriguez versus Illinois? I think
no, that's a different case. That's an appellate case. It's Hammond v. People, 199 Illinois 173 out of 1902. And then the latest one was People versus McGraw, and that was out of the second.
I heard about that case too. Go ahead.
1958. But we've always, since 1902, had in Illinois and in other states too, where there isn't a duty to retreat. And I'll land on this. I think the confusion comes where people confuse stand your ground with I must shoot. Stand your ground just explicitly states you don't have a duty to retreat. Now, whether or not you should use force, that's a separate analysis under state and federal laws.
Yeah, man. You know, people usually like to say, "I'd rather be judged by 12 than carried by 6."
Yeah, that guy's never paid legal. Yeah, they've never paid a legal bill. That person.
Yeah, exactly.
Right.
I don't think they understand how much they.
You're gonna learn real fast. Freedom ain't free, baby.
You don't want that either, right?
No.
I lost a lot. Look, you don't want that shit.
Yeah, and it never comes back, boy. I knew a lady that was I knew a lady that sat in jail for 2.5 years. It was a murder-suicide, and she very well may have done it, but she was proven, or she was not convicted after 2.5 years, and she walked out a free woman that owned nothing. She ain't get nothing, man. So yeah. And I'm all about self-defense. I'll absolutely defend my family and my life and my home and my possessions in the state of Texas, but I'm not anxious to do so. Does that make sense? There's a way to avoid it. And I go back to the stand your ground. I think a lot of people, like Jason was saying earlier, their argument is that it creates vigilantes. It absolutely adds no advantage to your self-defense situation. It just took away something that had to be answered. Or you're right. It didn't require a duty to retreat. But even in Texas, we didn't have a duty to retreat. But there was I can't remember how it was worded. It was changed years ago. But it was worded that almost like as if the reasonable person standard had to come in as to whether the person would have run or not. Does that make sense? Mm-hmm. So it was real vague the way they do it. And I think stand your ground is not a bad thing. It just eliminates a whole of the hearing process that has to be done in court and some determination that has to be made.
Joe,
I agree with the 2-part.
Can I say a question, Joe?
Yeah.
You have the biggest microphone I've ever seen in my life. Is that like a basketball?
No.
It's some balls, all right. I can tell you that much.
You like my mic, don't you? That's kind of gay.
No, I'm going gay. That is a monster microphone.
Now, what it is, it's got
okay.
It's
okay.
Just
the pop filter,
like a pop filter on it. Yeah, I'm cheap,
right,
bro.
well,
I'm cheap.
All right, I'm not gonna take up too much more of your time. I know y'all busy men and whatnot, and I wanted to, go ahead but I think it was a great show, and then give me feedback. Let me know how if you enjoyed yourself, if you're coming back, you want to talk about this again. I geek out on this type of stuff, learning about law and then trying to interpret it to laymen and try to say, hey, think about this. Think about the situation before you pull that trigger. Are you really ready to go through this? And so, yeah, I'm gonna start with you, Mike. Go ahead, give what can we find you at?
Instructor Mike. Facebook, Instagram, TikTok, same name, Yeah, it's, when you look at certain things, and I'll double down on what Corey said, it's conflict culture. Conflict culture, when you don't take into consideration the various cultures that you're a part of, and do they cultivate conflict? Because as much as I support the Second Amendment has a level of conflict culture within it too, where you're challenging a person to do something so that you can prove yourself great with this gun. And then I'm a victim of the system. Wait a minute, hold on. You didn't need to get into this thing. And so, that's another thing too. And so I'll just land on that as well.
All right. I know to find them at. Joe, what can we find yet?
I'm easy to find. Joe Lanou on X, Joe Lanou on YouTube, Joe Lanou on Facebook, Joe Lanou on Rumble. And
tell them about your show.
What I really do is I do the grand jury every Friday night. It's a live stream we do, and we broadcast it to YouTube, Rumble, and on X. I take 5 volunteers every week, 5 brand new people, and we place them as a mock grand jury, and we show them cases of police use of force and ask them to decide simply on the reasonableness of it. I've got a promo down if you'd like to run that in a few minutes. But Jason also, let me throw out on him. Jason is our co-host and our expert witness. He sits in as an expert witness for 30 years of law enforcement, and in his expertise to provide any questions to the jury, although we limit them a little bit because they have a tendency to follow whatever he says. So we have to we let his remarks come after the decision. But Jason's a good friend, and he's been on we're 50 episodes this Friday night. We've really got a lot more. We started counting 50 episodes ago. But give us a subscribe and give us a follow. Check us out. I'm always looking for volunteers for the grand jury. So anybody that's interested in doing that, just get my attention at Joe News. Send me a DM or call me. Doesn't matter.
Thank you, Joe. Go ahead, Jason. You tell us about 3D response and whatnot. I'm gonna play the promo after Jason, and then I'm gonna say my monologue and go ahead and get on out. Go ahead, Jason.
I actually, thanks for bringing me in here. This was a great conversation, and I agree with you, Corey. People need to educate themselves on stuff, and I can tell you from my perspective, at the end of the day, if you're involved in a situation, common sense, just, does it feel right? Can you justify your actions? Just use your common sense. If you don't have to pull that trigger, don't pull the goddamn trigger, because your life after that is going to be fucked up. Even as a cop, use common sense. If you have to pull it, be tactical about it. And then it goes beyond that. In your statement, make sure you can justify why you did. I just use common sense. Life should not be this hard. If you thought your life was in jeopardy and you want to protect your life, that's it. I was in fear of losing my life. That's really the threshold. And as far as 3D goes, my passion since 2002, after I was a school cop, I saw what we were doing to protect our children. I saw Sandy Hook. I saw Parkland. Like, nobody's doing anything about it. And I'm sick and tired. And my partners that are in this, we're all 30-year veterans in law enforcement, SWAT guys, school cops, active shooter instructors. We decided to take the bull by the horn and said, let's give them an actual response, tactical response, not technology. What's going to stop a goddamn bullet? And we provide that to the kids. So, and that's my passion now after retirement, getting that moving. And I'm not going to stop. And a lot of politics involved in it, which sucks ass, but it is what it is, and we're fighting through it.
Thank you. Let me play this promo. Then we on. I'm gonna say my monologue.
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.
All right, this is coming to the end of the show. No, actually, we're coming to the end of the show. I want to say this to everyone out there. It's easy to sit there Monday morning, quarterback every situation that comes across your screen. Everyone wants to argue about something, but the video only tells half the story. Then there's going to be long litigation that goes into it. If you think that you are ready to use that firearm and pull that trigger every single time there's a problem, well, guess what? The problems are only just beginning, and they won't stop for a long time. Whether you're sitting in jail for 2 years, 3 years, and then you got to think about the civil litigation that goes on after that. It's a hard thing. And if you don't make the right decision, you can find yourself doing 35 years. You don't make the right decision, you can find yourself doing 40 years to life. Everyone thinks they know everything about the law. Me, Mike, everyone, we see the people that come out of classes and they want to argue with us. I'm all for it. I'm all for the back and forth, but I want you to learn from it. I don't want you to walk away pissed off. Yeah, maybe I do, because maybe that shows that you can't handle a tough situation. Maybe you probably shouldn't be carrying. But it goes down to the fact of this, that you say you want change in your law. But if you don't know the law, you're not going to change shit. Thank you all for coming out.
They frame me in a picture, Sharpie horns on my head, every rumor like a scripture, they repeat what they were fed. Yeah, I'm walking through the whisper, let them burn me in their tails. I keep receipts in my ribcage, every scar, every DD. Call me the villain, paint me in black, blame every crack in your heart on my back. But when the curtain's falling and every mask is gone,